Good morning to everyone. I hereby call the Interim Joint Committee on the Judiciary to order. First meeting. Please call the roll, Robert.
Senator Berg. Senator Carroll.
Here.
Senator Deneen.
Here.
Senator Neal. Senator Schickel.
Here.
Senator Stivers. Senator Storm. Senator Turner.
Here.
Senator Wheeler. Representative Banta.
Present.
Representative Blanton. Representative Bratcher.
Here.
Representative Bray.
Present.
Representative Burke.
Here.
Representative Decker. Representative Dietz.
Here.
Representative Doan. Representative Flannery.
Here.
Representative Griffey. Representative Herron. Representative Kulkarni. Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosier. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Rawlings. Representative Sharp.
Present.
Representative Stevenson. Representative Wilson. Co-Chair Westerfield. Co-Chair Elliott.
I'm present. There is a quorum, so we are duly constituted to conduct business. The minutes from the December 15th, 2023 meeting are in your packets. Is there a motion to approve those minutes? There's a motion. Is there a second? There's a second. All those in favor, please say aye. Aye. And those opposed, no, and the minutes are adopted. I would like to recognize the newest member of our committee who is here with us, Representative Peyton Griffey from Bullitt County.
Thank you.
And welcome to the committee, and we are really glad to have you, and we know the people of Bullitt County are very fortunate to have you as well. So welcome to the committee, and we look forward to your work. I would also like to take a moment to recognize today's date, June 6, 2024, which is the 80th anniversary of D-Day, June the 6th, 1944. And I thought it was appropriate to read from the text of a radio address from President Franklin D. Roosevelt, who prayed with the nation by radio on June the 6th, 1944. And so in this poignant hour, I ask you to join me in prayer. Almighty God, our sons, pride of our nation, this day have set upon a mighty endeavor, a struggle to preserve our republic, our religion, and our civilization, and to set free a suffering humanity. Lead them straight and true, give strength to their arms, stoutness to their hearts, steadfastness in their faith. They will need thy blessings. Their road will be long and hard, for the enemy is strong. He may hurl back our forces. Success may not come with rushing speed, but we shall return again and again. And we know that by thy grace and by thy righteousness of our cause, our sons will triumph. So on this 80th anniversary, may we always remember the sacrifice of our brave servicemen in Normandy. So the first matter on our agenda will be House Bill 67, related to sex offender registration. And I invite Representative Banta to come to the table and any guests that she may have to present.
Thank you, Chairman and Committee. I did not bring any guests today because this is just kind of given the weather report for this bill. And I feared that any guests I would have would be more emotional entanglement than this committee really needs to hear. This bill is very simple. It would go from 1,000 feet for sexual predators in schools, playgrounds, etc., to 3,000 feet. Having never been a victim of a sexual predator, I do not speak with any knowledge, but I know that as an old principal that these affect people for the rest of their lives. And I had many people come forward and ask for this because it's beginning to impact some of our city areas and residents within. I did have people come to me and say, well, what about And I spoke with many therapists that said that you're always going to hear the excuse that they didn't know that she was that young, he was that young. They said that that's kind of a typical fallback. It's really not fair to use that when you're thinking about a bill. And they also, I was schooled on the nature of being charged, and there are age limits. For example, it's over 16, it's 18, and under, then you have to be 20 or older for certain. There's all kinds of scales that go with that. So I just left all that out and went with what the request was, which was 1,000 to 3,000. And if there are no questions, I'm finished.
Thank you. Thank you very much for the succinct presentation. I know, speaking earlier with Senator Turner, I know he seeks recognition, I think, to ask some questions, so I'll recognize Senator Turner.
Thank you, Mr. Chairman. I represent a rural area, and presently 1,000 feet is a football field in a straight line. 3,000 feet would probably prevent anybody from living in any small town in my counties. They couldn't even live there where they've got housing. We're talking about people that's been convicted, charged, out living, paid the price for their charge.
This is not retroactive.
It doesn't make any difference. You're still going to be punishing people that after they get out of jail, saying you can't live in the county basically that you lived in because there won't be no city they can live in. And there's not a lot of rural homes, so is there going to be any consideration of that whenever this bill is finally prepared? Otherwise, there's going to be a whole problem for all us poor rear people that have these small cities that take care of the homeless and everybody else. So.
And I appreciate that. And I am for a lot of things for people that have served their time. I would like to have automatic expungement. I would like to have voting rights, all those things. There's one thing you can't fix with jail time, and that's a sexual preference. And you're not going to fix a sexual predator, ever. They're always going to be a sexual predator. And I think that had I leaned on the emotional and I wanted to do that in this committee, I could have brought a lot of people that would have said that and taken up a lot of your time with the emotional and the background on sexual predators. So I don't really care about that because we can't fix it, and I don't want the next kid being hurt.
Mr. Chairman, can I proceed?
Please, go ahead.
In response to that, I'll have the Criminal Justice Department to get me every predator and what towns they live in to see if there are how many in our rural communities that you're going to impact. So we'll have some statistical information. I thank you for telling me that.
Thank you.
And so we'll all be prepared when January comes around that
Okay.
we'll have some statistical information. And I hope you would get that as the sponsor of that bill.
I would love that.
If you're going to pursue it so that you can, but I'll definitely do it because I have to. I represent my constituents, and it's landlords and communities that's got grocery stores and everybody else that's going to get impacted if you run off. And where are they going to live? I mean, they can't even live in the counties that I represent under this rule. So I just hope you take that into consideration whenever you bring that forward.
I do, and I also take into consideration the people that have been hurt by sexual predators.
I do. I'm a lawyer for 44 years, ma'am, and know
Yes,
all
sir.
about it. Thank you, ma'am.
Thank you, Senator Turner. I know we had discussions about you're leaving. I've got something I wanted to say before you take off. That's okay. I know we had discussions about this during the session, you and I, and one of the issues that, just to go off of what Senator Turner has commented upon, is that if you increase the distance from 1,000 feet to 3,000 feet, that could have the effect of forcing these individuals to move to more rural areas where a law enforcement presence is not as significant as in an urban area, which could have an unintended consequence of that person then living in an area where law enforcement is not as accessible to preventing future crimes. And I know you're trying to prevent future crimes and future victims, which is obviously a noble purpose, and I appreciate what you're doing. But there could be an effect, I think, unintentionally, of requiring these individuals to live in rural parts of a county, for instance, where there's only a sheriff patrol. I represent a rural area, so that could be, I think, a side effect of this that would concern me. Just playing devil's advocate, which I like to do from time to time. Senator Carroll has a question.
Thank you, Mr. Chairman. And looking at this from both a law enforcement perspective and the executive director of the Child Care Center, I absolutely support the limit. Help me understand how 2,000 feet is going to make a difference.
Actually, it was in my area, very urban. We have a school, 1,000 feet, football yard, and we have a very robust neighborhood right by that school. And evidently, the person sits on their porch with binoculars and watches the soccer games, and it kind of freaks everybody out. I've explained that would not impact them in any way because this is not retroactive, but they explained that they don't want sexual predators within 1,000 feet and binoculars on the soccer field. So I said I would try it.
Okay, and I understand that. I get it. From my history, I'm 14 years now in childcare. That's really not going to make any difference for us. The 1,000 feet takes care of that.
Does it?
But our center is there are lots of homes around. It's not really that situation where that would be an issue. Yeah. But I have not heard of this being an issue in the 10 years I've been here. So this is a new thought. And are we going to change the statute for one person? I guess that's the other question.
I guess the other thing I did was I got on and I looked at the number. I was shocked at the number in our area surrounding the schools. If you get on that website, it's depressing.
Yeah. Have you talked with KSP, FOP about the additional burden that's going to be to enforce these rules? Okay. I would suggest that.
Okay.
And again, it's not that I disagree with you at all. That distance needs to be kept, and we need to monitor that very closely. But I just have not heard from any other child care centers or any other school people asking to expand that. Thank you, Mr. Chairman.
Thank you, Representative Bratcher.
Kim, you keep saying it's not retroactive, and I understand that because in my district we had a fellow that moved right next to a school, a private school, and he was about 505 feet away or whatever, because it used to be 500, and then we expanded to 1,000, and then all the mothers and whatnot came to us and said, this guy is breaking the law. But then we found out that because it was a retroactive thing, that he wasn't in any violation because he was convicted when it was 500. Mm-hmm. So my question is, and I don't know if the will of this legislature would want to do it, but could we get rid of the retro, number one? Number two, is there some kind of constitutional thing, maybe the lawyers here could answer that you can't make something like that retroactive? And I'm just really thinking out loud of something to consider. If retro would be the right way, because when this law can't. Okay, well, forget it then.
Thank you.
Thank you, Representative Banta. And we have someone scheduled to speak in opposition, Scott West from DPA, if you'd come forward and give your testimony and introduce yourself, and then we'll See if we have any questions or comments. You're recognized.
Hello, and thank you. My name is Scott West. I'm the Deputy Public Advocate for the Kentucky Department of Public Advocacy. And I come to you today as a 25-plus year public defender. And I do appreciate the intent behind this bill. I'm not just a public defender. I'm a parent. And I raised a child, and I was very aware of the Kentucky State Police website. And I would periodically look at it because I do believe that safety in the community is important. But I wanted to share a couple of my insights and to be sure, Senator Turner, Senator Carroll, and Chair Elliott, you all have touched on these to some extent. But of the 36 or so that I can count by name of persons who are charged with sexual offenses against children, and this is in eastern Kentucky, this is in western Kentucky, and it's in central Kentucky. I've been all around DPA. Almost to the person, I can only think of 2 counterexamples out of about 36 cases. The person was known, the victim was known to the person, and they acted in seclusion, far from any supervision, often in a very rural area, whether it was a farm road or a hollow or something like that, outside of supervision. And I remember, if you all remember, some of you remember, when you all passed the 3-year post-incarceration supervision for sexual offenses, and now it's been expanded to 5 years. But the selling point all those years ago for that is that when you're in prison, you're not around children, but neither are you learning skills to cope with your predilection. I agree with Representative Banton. Every expert that I've ever heard talk about it says that it's not something you outgrow. It's not something that you become something different. But what you do in that period of time when you get out of prison is you are supervised by probation and parole, and you are done so in such a manner that you're learning skills, hopefully, so you can cope with what society demands and what the law requires. That's hard to do if you're 30 miles from downtown. Most probation parole offices, I think, are located pretty close to a downtown area. And if you expand to 3,000 feet and draw concentric circles out of all the daycares and the schools and all the other places, you quickly find out that it is pushing people to rural areas where they can least be supervised and least learn the skills. Also, as a public defender, I can just tell you it's easier for a poor person to live in town than it is in rural. You don't always have a car, you don't always have a job, there's not always affordable housing. And so forcing people outside the downtown area is pushing the problem out, but it's also creating a situation where this person is losing the basic needs that they need to live, and I think creates a constitutional issue there. I will say this, and that is that I haven't talked to probation and parole, but it is my belief that they have too many cases. They have too few people. They're not paid enough. I feel like that they share that in common with a lot of people in the criminal justice system. But if I was to offer a potential solution to look at Representative Banta's example, further fund probation and parole, and for people who live within 3,000 feet of a school, have some benchmarks to increase the supervision while they live there. And then you're not foregoing your supervision. And then if someone moves outside of the 3,000, then they're moving outside of greater supervision. But for those that are close to the schools, fund probation and parole so that they are able. It's just logic dictates that it's easier to check on someone and do a routine random stop who lives a half a mile away from the office than someone who lives 30 miles away from the office. There's more potential for supervision. The last thing I'll say is a lot of people who are convicted and they serve their time and they get out, they are trying hard not to reoffend, and they're in need of mental health services. And often those are in town. And you have to be able to get to them. There's only so many places that offer the resources that we want. And when these people get old, some of them are in need of nursing homes. Some of them, their families take care of them, but when it's outside of their family's ability to care for them, they may seek assisted living homes. They may seek nursing homes. They seek placements where there are staff that are keeping care of them, but also knowing where they are at all times. I'm afraid that what this is going to do is create a situation where you're not going to be able to send your loved one to a nursing home because they're all within the prohibited residence area. And it's a thing. Google it. Sexual offenders, nursing homes. Google it. It's a problem nationwide. And so I would ask that you all look at least some exemption also for persons who are confined to a nursing home where they have persons watching them, so that when someone gets dementia or they otherwise become infirm, and they're no longer relying upon what they learned in their supervision and classes, and may fall back to potentially reoffending, that they are somewhere that they can be watched over and not left and forgotten in the places where it really is hard for a poor person to live out in a rural area. That's all I had to say, and thank you for listening to me.
Thank you, Deputy West. Do you know across the country, and if you don't, that's fine, is this 3,000 feet proposal, would that be consistent across the country, or is the 1,000 feet more consistent with the law across the country?
I did not look at the law as for the feet. The articles that I've read are more general. Like I read one in Kansas where there were 7 people that lived within a prohibited area from the school. I think that's kind of, I don't want to say arbitrary, but I mean, whatever number you choose, there's going to be people living just outside of it and just inside of it.
Sure.
And the issue is, do you have enough room in the city that someone can live in a nursing home?
Yeah. Is there any other discussion, any other member seeking recognition? If not, then we thank you.
Thank you.
So our next item is wrongful conviction compensation, and that was House Bill 178. During the session, Representative Nemus is the sponsor, and if you would introduce yourself, and I know you have several guests, and if they would do the same, then you can proceed.
Thank you,
And
Mr. Chairman.
This bill did pass the House Judiciary Committee, as I recall, so it did
That's right.
move through the process to some extent, so
All right.
you're
I'll
recognized.
let everybody recognize themselves. I'm Jason Nemus, State Representative from Jefferson, Oldham, and Shelby counties.
Suzanne Hopp, Kentucky Innocence Project Directing Attorney.
Winnie Yee, the Innocence Project.
Jonetta Carr, Exoneree in Kentucky.
Edwin Chandler, Exoneree in Kentucky.
Michael Von Ullman, Exoneree from Kentucky.
Thank you, Mr. Chairman. So I'll start off, and then we'll have some other people testify if I might. Let me start by saying sometimes it's not enough just to say my bad. And we recognize that in a lot of ways. So if I'm on the basketball court and I hack you or I foul you, I can't just say my bad. You get free throw shots. If I throw a high and tight and hit you in a baseball field, I don't get to say, John Schickel, my bad. You get first base. There's a consequence to that. If I interfere with the football pass and stop you from catching the ball, Peyton, I don't just get to say, yo, my bad, my bad. No, you get 15 yards. Sometimes you need more than just my bad. And in this situation, when the government makes a mistake and we convict somebody, we don't just get to say my bad and open up the prison doors. We have responsibilities. It was a lesson I learned when I was a young man. When I threw a ball against my house, it bounced off and broke a window with the next door neighbor. My dad just didn't let me say, Mr. Schneider, that was our next door neighbor, my bad. I went to the hardware store, Representative Bray, and I helped him find a window, and I got to learn how to replace a window. There was a consequence to my action. I couldn't just say my bad. Similarly here, we as a state legislature have an obligation to those who have to show that they are actually innocent. It is not enough, Representative Maddox, to say we got to overturn the conviction because the constable has blundered. I have to do more than that. I have to show I didn't do it. I'm actually innocent. And so if you show that you're actually innocent, only then would you come under the protections of this act. And what does it do? It gives you $65,000 a year of that you were incarcerated. The average incarceration of A wrongful conviction of those 21 people in Kentucky is about 10 years. And by the way, of the 21 people who would be eligible, many of those have already had a civil judgment. And if you get a civil judgment, you can't get both. So those would not be eligible. So the 21 number that we put in our materials, that's the high end. That's not the real number. The real number is we think about half of that. It also allows you to get things like, court costs reimbursed, attorney's fees up to $25,000. Representative Flannery, sorry, you won't be able to charge your normal rates. You can only get up to $25,000. Child support that was accrued while you were in prison, obviously, you won't have to pay that. The point of this is to say you've been wrongfully convicted, so you shouldn't have to take on any of the water that you took on while you were in prison. We also give you counseling to make sure you get back on your feet, which we give right now to people who've actually been convicted and then they're going out of jails, but we don't give people to people who are wrongfully convicted. And the last thing I want to note, and I think this is important, getting out of jail, getting compensated what you should is important. But I know these people. These people have become my friends. The best part about this bill, don't forget we need the compensation. It's easy for me to say, is they get a piece of paper from a court that shows that it's a certificate of innocence. We have put them in front of society, and we've said, you've done this heinous act, this bad act. We put you in prison next to people who've done heinous acts. And their parents sometimes died, their brothers and sisters, their loved ones. They've lost girlfriends. They haven't been able to see their kids. They get a certificate of innocence that they can hold up to the world and say, I'm innocent. What a joyful day that must be. That's in the bill as well. Okay, I'll be quiet. Just want to say sometimes you just can't say my bad.
Thank you for allowing us to address this issue in front of the legislature again. I'm Suzanne Hopp, directing attorney with the Kentucky Innocence Project, and I personally have met folks at the prison gates in their mid-60s who have been incarcerated for 20-plus years and watched them walk out, innocent people, wrongfully convicted, with a garbage bag in one hand, and that's all that they own. They suffer an extreme loss of liberty, the worst loss of liberty that I think the state can enact. They lose their time, they lose their families, they lose their homes, they lose the confidence of their communities, and they have to come back and they have to rebuild all this. And it can be very, very difficult for them to obtain any kind of civil relief. It takes an average of 5 to 7 years to obtain civil relief. During that period of time, they have nothing. I've seen folks that we've represented that are homeless, that they have no family left to go home to. Their parents have died, the aunts and uncles that knew them when they were younger that might have been able to support them, they now need support of their younger family members, so they have nothing. And I want you to recognize that the state gives more support to people who are guilty when they walk out of prison than those that are innocent. Folks that are guilty, that are leaving on parole, they get some sort of halfway housing. They get social workers that help them keep them on the straight and narrow. While our innocent individuals that are walking out, they've established their innocence oftentimes in a court of law at a very, very high burden. The burden is extremely high to establish their innocence. And they're walking out with nothing, and they're trying to put their lives back together. So we ask that you consider just, once again, listen to the stories of Kentucky's exonerees and think about how important it is for you to pass this law.
And I want to say, apologize up front for Janetta. The Lord broke the mold when he made Janetta Carr, so you're going to fall in love with her just like everybody else, but I don't apologize up front. She's wonderful.
I'm going to try not to get too today, but this has happened in my life and I'm still healing from it in real time. We the people, in order to form a more perfect union, establish justice. I learned that when I was in around the 5th grade. It was part of our elementary school curriculum, and at the time I really couldn't grasp the concept of it or what it meant. I've shared my story here many times. Today I would like to talk to you about a different part of my story, which is forgiveness. I remember around the time of my sentencing, I wrote a letter to the judge, and in the letter I told the judge that I forgive the system and also the people that accuse me of a crime I didn't commit. I had to forgive the system because every night while I was in that cell awaiting trial for a crime I didn't commit, I would pray to die. Not only did I pray to die, I had several suicide attempts, but I'm happy that I'm still alive today and that God had other plans for my life because I'm living in my freedom, even though I have not fully got a chance to experience justice yet. My wrongful conviction is present every day of my life. Even though I had to forgive the system, it's hard for me to forget what I've been through. Like when I go fill out job applications, I have to answer the convicted felon question. Or like me and my nephew was talking the other day, and he remembers a time when they needed their auntie to step into their life and be a role model and a parent to them, and CPS actually came back and took them from me because they pulled my record and it came back. I see it in pictures when my family, shares pictures of different memories, family vacations and things that they had, and I'm missing from those memories and those pictures because I was in prison for a crime I didn't commit during those times in my life. So I just want to say that we cannot forget about the wrongly convicted in Kentucky, just like our founding fathers didn't forget that because the system is made by humans, and as we are humans, none of us are perfect. And it's okay, but at the same time, we just cannot forget about the wrongly convicted in Kentucky, and I support this legislation. Thank you.
My name is Edwin Chandler. I'm also an exoneree from Kentucky. I was convicted in 1995. I did like 10 years in prison. The biggest thing for me in this situation is getting out. Once I got out, I didn't have anything to turn to. I didn't have anybody to turn to. I didn't have any family members because everybody were under the suspicion and suspect that I committed this crime. It wasn't until I was able to form a legal team and file a 1983 claim that I was able to receive compensation for the charges that I had been locked up for. That took about 12 years total. I suffered for that long, not being able to get a job. I went on 100 interviews and everyone ended the same exact way. Mr. Chandler, we're sorry that you had to deal with that, but because you're a convicted felon, we can't hire you. That is tremendous for a person who hasn't done anything, who needs to reboot their lives, who just can't. I wound up moving away about 10 years. I moved to Atlanta, and I started my own nonprofit foundation called the Chandler Project. And it helps in just that regard. When individuals are released from prison and they don't have anything, they call me. They call my director for resources, housing, just simply money to buy food, clothing for their children. I help in a lot of different aspects. But what I need you to understand is that really I shouldn't be here doing that. I shouldn't have to do that. That should have been a resource or an outlet for those things. And because they're not, then I have to take on an extra burden of helping other exonerees try to master getting their life back on track. So definitely this bill is going to help in a lot of different ways for a lot of different people. And I really thank you for having us in today, for giving us the time, the opportunity to share with you. Thank you.
Mr. Chairman, members of the committee, thank you for hearing this about wrongful convictions. On October the 29th, 1981, I was blindsided when the police came to my house and arrested me for a rape of a woman I had never seen before in life. The absence of anything serious on my record led the judge to set this incredibly low bond, and I was out the moment that bond was set. The next day, December the 30th, 1981, I ran into a friend that I had known since high school. He says to me, look me straight in the eye and tell me you didn't commit that crime. Scrutiny of me as a sex offender began day one. That was 43 years ago. 30 years ago, the parole board scrutinized me for the fourth time, And when I went there to prepare to meet them and only talk about my accomplishments in prison and how I was going to be a good citizen on the other side of the fence, they only had one question. Did you do it? And I'd already met them 3 times before. The answer was always the same. I never saw that woman before. Now it's been 30 years I've been out. 14 years ago, the Innocence Project got my case and uncovered this incredible mistaken identity case. That was 14 years ago that the truth came out. 43 years ago since the crime, and I still find myself in situations where I'm feeling the full disdain that we all hold for the sex offender, the pedophile, for the convicted felon. I've been scrutinized this entire time. This bill gives me a chance to be scrutinized by the court one more time, that where I may be compensated for the harm that endures still, even after this compensation bill passes, if it does, I will still be scrutinized as a convicted sex offender. That doesn't change being able to pay my mortgage off May. That will help. I hope you all consider the bill and pass it. Thank you.
Thank you, Mr. Chairman. We also have Paul Hurt in the second row behind me, who's also an exoneree. These people are the best. They didn't do anything wrong. And in order to get compensated, Representative Doan, they have to show they didn't do it. So with that, we'll take any questions, Mr. Chairman.
And I fully support this bill, as you're well aware, and we'll vote for it in the future if we get that opportunity. Senator Schickel, you're recognized.
Thank you, Mr. Chairman. You know, I believe that we have the greatest criminal justice system in the world. If you look at the different features of it, it's really quite something. But there are times when we make mistakes. Sometimes you get the impression from sitting on this committee that we don't have a good criminal justice system. I totally disagree with that, but there are times when we make mistakes. You know, I can remember a time when you couldn't use DNA for post-conviction evidence, and the Innocence Project championed that. I mean, it's hard to comprehend now that they could use DNA to put you in prison, but in Kentucky you couldn't use DNA to get you out of prison. It's hard to comprehend, but the Innocence Project fought that fight, and eventually now that's law. Today you can use post-conviction DNA. This is important work, and I agree with you totally that when a mistake of this magnitude is made, there needs to be more than just "I'm sorry." I do have one question for you, because I think it's an important question. When you say they have to prove that they're, you know, they have to actually be innocent, for a layman like myself, what is the procedure versus a technical mistake in the law versus showing your innocence? How does that play out? Because I think that's important to a lot of people who have to make a judgment on this bill.
Yeah, so all over the bill is they have to show they did not commit, they're actually innocent. And so what would happen is they go to circuit court and they have to make a showing. They have to prove that they didn't do it. So it's not enough to say, hey, my rights were violated. I asked for an attorney, but they questioned me anyway. That's not enough. That might get you out of jail because there was evidence that was used that was not supposed to be used. But that doesn't do the trick here. You have to go and show actual innocence. You've got to show, as Mike has shown, that someone else did it, or the DNA wasn't mine, or I was out of the state at the time. So just because there was a mistake or even negligence or even bad faith on behalf of the officer, that doesn't cut it. You have to show that you didn't do it. And so I'd like to ask you to comment more, but
The bill specifically enumerates the reasons that a certificate of innocence would be issued and when somebody would be eligible. And so it goes through it point by point, that the conviction was either reversed or vacated, the charges were dismissed on retrial, and the claimant was found to be not guilty. So there's an actual finding that has to be made. So it's not just a matter of, is this a legal issue? For many cases that return to court, either through the appellate process or the post-conviction process, those cases are actually subject to retrial. And for the majority of the Kentucky Innocence Project cases that go to court, we do that under an evidentiary standard that is either reasonable certainty or reasonable probability that the outcome would have been different. But even once that has been achieved, then you have to go through these additional steps. So there's, for Kentucky Innocence Project clients, they would be returning to court, creating, going through a substantial burden, specific burdens of proof depending on the type of claim, and then even after that occurs, that case is actually, in general, subject to retrial. So in order to be eligible for this fund, there has to be an additional finding that the conviction is either vacated, dismissed, and that the individual has established their conclusive innocence.
And again, I want you to understand the word "and" is used there. Vacated and prove your conclusive innocence.
Thank you, Mr. Chairman. Thank you for that explanation.
Thank you, Senator. And it looks like it has to be proven by preponderance of the evidence as well. Is that right?
That's right.
The interaction with the, and I know we've had this discussion before, Representative Nemes, but the claimant was granted a full pardon by the governor. Now, you and I know that sometimes when somebody's pardoned, they're not innocent.
Not enough.
So that's not enough. Okay. There's an or there, so that's the only reason I asked that question. Representative Flannery, you recognize.
Thank you, Mr. Chairman. Some brief comments and a couple questions, please. I'd like to echo the statements by Senator Sickle. I agree 100% with his statements. I support what you're attempting to do, Representative Nemes. I voted for this. I believe this is a really good bill. I guess a couple of friendly critiques. Representative Elliott talked about the burden. It says preponderance of evidence, which is, I guess, overwhelming majority of most civil cases. That is the burden of proof. However, there are some civil cases that have a more heightened burden of proof, clear and convincing evidence. I'm just kind of wanting to know your thoughts as to whether or not that may be a more appropriate burden of proof on this case, due to the fact that the claimant actually has to prove their innocence in this, so it actually has a more heightened burden of proof for that claimant to prove. And then the second question, it looks like the Finance and Administration Cabinet is given the obligation to make payments on this. Is there a funding mechanism in this bill that would come out of maybe court fees or court costs or something like that that would help seed this fund to provide claimants that have been deemed to be innocent to receive these monies?
Yeah, so I think preponderance of the evidence is the right standard, Representative. For those who are not attorneys on this committee, preponderance of the evidence is more likely than not. So you've proven, you've convinced somebody. It's 50. If you're going to do it in percentages, 51%. Clear and convincing evidence, I don't know what, I guess 67%, and then there's beyond a reasonable doubt and so forth. I think preponderance is the right, because you still have to make a showing that you've convinced the court that you didn't do it. I don't think you should have to go all the way up to clear and convincing. That's a change I'd like to think about. But let's look at when you're defending yourself in a criminal case. If you say it's if you have a self-defense, I think that's just preponderance of the evidence. I don't do many criminal cases, but I'd like to think more about that. But I think preponderance is the right standard here. With respect to the fund, that's in Section 2 that begins on page 6 of your bill. The fund is overseen by the state treasurer. It's funded by appropriations, gifts, grants, and federal funds. So the lion's share of it would be state appropriations, Representative Flannery.
Senator Carroll.
Thank you, Mr. Chairman. Representative Nemes, get in the weeds just a little bit. On page 6 of 8, line 25, when it talks about the destruction of biological samples, make sure I'm understanding the language correctly. In the event that the offense that the accused is being cleared of, a biological sample from that offense that led to a charge on a separate offense, would that evidence be protected, that sample be protected if someone was exonerated? It's a little bit confusing, and I mean I could see with a chain of evidence on the offense that they are maybe currently being prosecuted for, had been convicted of, the need to preserve, make sure that sample that was the original sample that led to evidence on the other conviction, that be protected and not be disposed of.
Yes, Senator Carroll, thank you for that question. That's something that we thought through and something we strongly believe in. And so the bill has this language in it. I've got a different version than you have. On mine, it's page 6, starting at line 8. It says, but this is still in the version that you have, or it should be. Nothing in this subsection shall require the KSP to expunge and destroy any samples or profile records associated with a claimant that are related to any offense other than the offense that the court has issued a certificate of innocence. So what we're saying is, if it's related to the charge that you were convicted of wrongfully, it's out, gone, see ya. But if that information is related to or will help a prosecution for maybe something else that you have done, then you don't have to destroy that. That's something we thought through. And
I just wanted to make sure, because the wording it could be interpreted either way, but that's what I thought it said, and that would be crucial to be able to protect.
If we need to be clear on that, we're certainly willing to do that. I'll also note, if there is, if someone is serving time for 2 convictions, one that they were wrongfully convicted of and one for something else, they don't get compensated for that year. Just want to make sure. So we look through that to try to be fair, and not give more than what is due.
Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator.
Representative Maddox.
Thank you, Mr. Chairman. Representative Nemes, I have a question for you. We passed this bill this year back on January 17th, and it has a multitude of co-sponsors. I voted for this bill. I support this bill. I know a lot of other folks do as well. Why, and maybe you know the answer to this, why did it not come to the floor? Why did we not vote on this bill?
Yeah, there was a lot of discussion among a number of members, including in our appropriation and revenues and myself, and we thought that it has some things in it that can be worked through a little bit more. We were worried. Some were worried a little bit about the necessary government expenditures portion. The people on this committee would know probably that we appropriate dollars, a particular amount of dollars, and that's what most government units have to stick to. But some things like corrections, if they go over and above, then those extra expenditures have to be made. That's in this bill, and I think some were wanting to make sure that they had a real grasp on how high that could actually go. We have that number, by the way, the number with the 21 people, and again, not all 21 would qualify, but to be overly conservative in budgeting, the total dollars would be $12 million. It's going to be much less than that, but that would be the total number that would be eligible. But it was a discussion about how we can make sure that we have a proper grasp of the outside cost here.
Follow-up remark, Mr. Chairman?
Yes, go ahead.
That was again January at the beginning of session. We had several months that we could have worked on that. These questions that you had to deal with about your bill, I understand that must have been frustrating from you, but moving forward, I would like to offer the critique that there are a myriad of things that we do have time during session to address, and I think that it's good that we use the interim, but this is an important bill, and we need to get the job done. Thank you.
The good thing is we got a commitment from all parties that we're discussing that we would take a serious look at this over the interim with an effort to try to get it past this next session. No commitments that it would pass this next session, but we got an effort from all the players that this is on the front burner issue for the interim.
Thank you. And do we have any other members seeking recognition or discussion? I did have one question, Representative Nemes, that came to mind. I always like to ask this question. It seems maybe with every bill, so I sound like a broken record. Has any other state adopted a measure like this, or is this bill drafted to another state's law?
Yeah, so there's only 13 states that have not done this, and the federal government did this as well. President Bush signed this bill in the early 2000s, and the compensation there was $50,000, which would be with inflation over $80,000. per person. That's for a federal offender, so it obviously doesn't affect Kentucky state offenders. So, we are, as Mark Twain said, if the world ends, you want to be in Kentucky because everything happens 20 years later. We're not inventing the wheel here, buddy. Well, we're one of only 13, shamefully, we're one of only 13 states that don't properly do more than just say my bad.
And had I looked at the handout from the Innocence Project, I would have known that.
We are glad you allowed us to highlight that.
Had I done my homework. Representative Wilson, you're recognized.
Thank you, Mr. Chair. I didn't anticipate having any comments or questions on this until I believe either in the session or the last interim when they put a map up. I want to say it was the Kentucky Innocence Project. This may be the 21 cases you're referring to. And there was a case in our circuit where I can't recall why it was overturned, but I know it wasn't retried because of the death of a witness. So when you say not all 21 would be eligible for this, is that case included in someone who may not be eligible because the evidence is gone for one reason or another?
Yeah, if I may address that, that would be one of the, we anticipate at maximum 50% of the 21 exonerees would actually be eligible. And there's a good likelihood that a certain percentage, and I know the national estimates are about 75% of individuals that apply don't receive the certificate of innocence and don't receive any funds. So that would be definitely one of those cases that we included that would likely not be eligible.
And again, if the evidence is gone, I don't like this answer, but you've got to prove you're innocent. I'm going to hold that line. I will not move from that line. So there may be injustices where people who should get it don't. But the overwhelming majority of those who should get it will be able to prove that they're actually innocent. So I'm not willing to move on that line. They've got to prove it.
Thank you very much. Representative Petrie.
Thank you, Mr. Chair. Generally in favor of looking at the issue, and I've talked about this, and it's not just a money issue, this is a justice issue. But I would be remiss for today if I didn't at least draw a little highlight on this so that we can make sure I get my conceptions straight. For me, there is some problems in the bill and the mechanics. I think those can be worked through, but it's going to take work to get through it. But as a conceptual matter, we keep saying innocence, 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 and we have to make sure there's good context around that. There's nothing in our court system to date that sets you as innocent. That process, the entire justice system, is not situated or made available to determine innocence up to this date. It is determined whether there is guilt or not a finding of guilt. So when we say innocent, prove innocent, I want to make sure that people look past the catchphrase of innocent or prove your innocence. You're asking a system to do something it's not designed to do further. We talk about what's the standard of proof, whether it's going to be preponderance or whether it's going to be something else. Just like was made mention of, sometimes evidence goes stale. Sometimes witnesses aren't available. That is taken into consideration when a court is looking at that preponderance of evidence, if that's the standard. I can't tell that exactly, but I take it as what's been said. That's the lowest standard we use, and we only use it on civil. You're looking at issuing a certificate of innocence, which is a very, very strange thing in criminal justice, based on preponderance of evidence, which is a standard we don't use for guilt definition or guilt finding in the justice system in Kentucky and probably many other states. I want to make sure that we're clear about our phrasing and then the legalities, the mechanics that we've got to deal with in the bill. There are other issues, and we've mentioned a few of those. Now, please don't take those comments to be that this bill is so flawed it will never fly. I don't think that. I think these things are correctable, but I just want to make sure everyone understands there's some significant work to do to get to where I think most people are trying to get to. Money's an issue also, but there's a bigger issue on criminal justice and how we make sure this fits into our system. On that, I see the Innocence Project's sheet that was handed out. I'm going to assume that the states that have adopted some type of mechanism like this are not uniform. Would that be correct?
Thank you so much for the question. What you just described about a certificate of innocence, that actually is based off of Texas's law that was passed. So there are a number of states that have done certificate of innocence and have the same standard.
Correct. But my question is this. I assume, correct me if I'm wrong, that all of the laws passed in each of the states that you're talking about are not a uniform law. They're specific to their state.
That's right.
Yes.
Okay, that's what I wanted to make sure of.
Yeah,
Thank you, Mr. Chair.
I do have a couple comments.
Sure.
Chairman.
I wanted to say one thing, and then I'll yield
Thank
to you. I think the way I look at this, and I appreciate the discussion that Representative Petrie has had, I think when we look at guilty or not guilty and innocence, the way I look at it is if you have to, innocence is above not guilty. And so you're going to have to go in and obviously prove something that you don't have to prove as a criminal defendant. So I think he's exactly right. I think in the Scottish system, there's a verdict of not proven, which we don't have here. But the way I view it is that the innocence requirement here is above and beyond not guilty in terms of what I would have to prove as a criminal defendant going into court, showing that I was innocent beyond a preponderance of the evidence with a very extensive list of things that I have to prove. And someone who's innocent maybe possibly couldn't even prove this.
Right.
And so I think it's a very tough standard to meet. But I appreciate the discussion that he has had, but I view it as more of when we look at innocence as being a higher standard than not guilty.
And I would note, Mr. Chairman and Mr. Chairman, I really, really, really want your vote. But if I can't get it, I still want this to pass. I don't want any individual, even myself, to stop a bill that I think I'm going to get over 80 votes for. So I'm going to try I'm going to hunt that vote as far as I can hunt it. But I want this bill to pass with you, certainly. I won't finish the rest of that sentence. Let me also say, we do use preponderance of the evidence in the criminal context. In an affirmative defense, on behalf of the defendant, they have to prove on self-defense and other things. Not to establish innocence, that's fair. But the same system, the same judge, the same clerk, the same bailiff, the same system that does criminal cases turns over the page and they've got civil cases where we have preponderance of the evidence and these types of proofs, these types of standards all over the place. Lawyers know how to make this showing. This is not some kind of animal from another country. This is in the same courtroom 3 seconds later. We go to motion hour, you're going to have 20 criminal cases and 40 civil cases where the standards deviate left and right and front and center. We do not have, like some states have, civil appellate divisions and criminal appellate divisions. So the same Court of Appeals judge and the same Supreme Court justice in one oral argument is going to have this big esoteric discussion about proof beyond a reasonable doubt, and the next time they're going to be talking about various other standards. So this is not something that's foreign to our court system. We can get this done like most other states have done it, and we're going to get it done with Representative Petrie as a co-sponsor.
And I think it's very hard to prove with the way you've set it out here. I think it's still a tough hill to climb for somebody who is innocent if you have to prove all these things. Is there any other member seeking recognition? I don't think so. Okay, so we appreciate your time and appreciate your testimony.
Thank you, Mr. Chairman.
The next item is House Bill 599, an act relating to destructive devices, and that's Representative Emily Callaway, and she has some guests with her, and she would proceed to the table. And I'm told that the proposal in the folder is for the 2025 session. So you may proceed. Thank you.
Thank you, Chairman. And that is despite the fact that you have me following our witty whip there in the agenda today. But I do appreciate the time to take a look at this. I thank you to, I affectionately call them the Ryans of the FOP, who have agreed to join me today. Would you like them to go ahead and introduce themselves now?
Please do. And
Ryan Straw, State Vice President, Governmental Affairs Director for the Kentucky State Fraternal Order of Police.
Is Ryan on Zoom?
And you can proceed. Thank you.
Okay. I had the other Ryan was calling in on Zoom today. So.
Oh, okay. Is he on Zoom? Okay.
Oh.
We don't see him, so.
While you speak, I'll verify that.
Okay.
Okay. So the objectives that we're hoping to accomplish here is to better protect public servants who go into unknown environments, to better protect the public who may have neighbors who have nefarious intentions, and also to define some common tools that are used in destructive devices and booby traps, and this will better federally align. And then to address intention when using devices. So that's what this does. It's fairly short, cut and dry. My hunters that I've reached out to, Second Amendment advocates, do not see any problems with it. Fiscally, minimal to no impact. And really, we just honed in on some of the issues that we had seen in the field, that they had seen in the field. Got local input from my LMPD, and this is what we think will empower our public servants to feel more safe and secure, and really put some tools in their tool belt to go after people who would have gotten away with something that, though it didn't cause immediate damage, it could have. Do you want to add something?
No, everything Representative Callaway is talking about is absolutely correct. The state FOP, and again, Ryan's waiting on Zoom, and he is the subject matter expert on this, so I don't want to definitely take away from him, because I think if you have any questions, this is a man that did this in the military, who served overseas doing this, and then with Louisville Metro Police has done it for almost 20 years. So he absolutely knows what's needed in this. But I did want to say there were, I know when we worked on it last session, there were some concerns that it may affect some folks that we weren't intending to. I will tell you that, and Ryan may hit on this, the onus for this is the fact that our state law enforcement really had no ability to enforce something like this happening, because there was no law on the books, and he has seen this in the field, and so we wanted to clear it up. And so there's Ryan now. I'll let him. This is the president of our largest FOP lodge in Louisville, and former Louisville Metro Police Officer Ryan Nichols.
I'm Ryan Nichols, president of the River City Fraternal Order of Police Lodge 614. Thank you all for the time. I apologize for whatever confusion that was on the Zoom connection. But as Mr. Straw stated, this and Representative Callaway, this is just to allow some avenues for prosecution here in the Commonwealth that don't necessarily have to go federal. The changes in the definitions in some of these statutes closely mirror the federal statutes and some other surrounding state statutes, but sometimes a case probably is more appropriate in state court. There's times where it's more appropriate in federal court. And not having the ability to pursue those state charges force one to go for the federal charge when that might not be the right way to go.
Is there one specific case, I know when we had discussions over the interim, that you can sort of talk about that brought this to attention, I guess, in Louisville?
Sure. So back in August of last year, we had an individual who enjoyed playing with his grown-up chemistry set, to put that lightly. He was a hoarder, and while he was hoarding and playing with chemistry sets, he created thousands of pill bottles full of unknown concoctions, to the point where when it was finally brought to LMPD's attention, they could not even send the robot in to retrieve any samples because the level of hoarding was so bad. So this was an unprecedented circumstance. And then in dealing with it, we were having to have town hall meetings. The impact of this was the ripple effect of it, the fear that my constituents and neighbors felt about this, not knowing if this house would just explode at any point, if they were going to set fire to it, a controlled fire. There was a discussion about having a controlled fire. People had concerns about their livelihood, their safety, their animals. This was going to be impactful, and still may be. We're still dealing with the impact of this. And they take the guy into custody, and I can't tell I don't remember how long it took, but he's out walking the street because there wasn't anything to really hold him for. And because nobody was actually injured, which I would counter with, there was some absolute emotional injury. There was people took off to attend meetings. So it is impactful, and there was nothing in their tool belt to be able to handle this appropriately.
Thank you. Is any other member have discussion? Representative Petrie.
Thank you, Mr. Chair. Really quickly, and I haven't gone through this bill thoroughly, so please forgive me, but I'm just trying to make sure off the draft that I'm looking at on page 1, section 2, existing with some modifications. One looks like will be A. There's an intent component to use the device for a purpose. Go on to the next page, page 2. There's also an or knowledge, so intent or knowledge as a component of the crime. And then on line 5 of page 2, mere possession without substantial evidence of requisite intent is insufficient to bring the action. Looking at section 3, I see no language regarding intent or knowledge or any kind of mens rea about the criminal act that's taking place. It almost looks like a strict scrutiny, strict liability. I didn't know if that was by intent or if I'm missing context somewhere else. And do you see any issues with not having any intent or knowledge or reckless behavior involved in the activity itself?
So that is the intention there, is to make sure that there's clear intent established before pursuing it. And then that is the second degree, that's where it's second degree versus first degree. And that was definitely intentional, which is the reason for the addition before section 4 there.
If I may, Mr. Chair?
Yes, please.
Yeah, I may not be making that question really clear. I'll be glad to talk with you offline about it to make sure that I'm not missing something. Just want to make sure change. I can understand that we don't have prosecutors and defense counsel in a tizzy about something we let slip through if we could have caught it.
I look forward to that, and I appreciate it.
Very good. Thank you.
Thank you very much, and we want to wish you a happy birthday, Representative Callaway. I know it's tough to have to spend your birthday before the Judiciary Committee, but happy birthday nonetheless.
Thank you,
Does
Chairman.
anybody else have a comment or question? Great. Well, seeing none, we appreciate your presentation.
Thank you.
It's the final item on our agenda. Is there any other business to come before the committee? And if not, we'll stand adjourned.